Yep, I just got a notice.
All right. Hey, everybody. Welcome to the AI Unplugged Mastermind. Today we have Don Ho, Esquire, which means he's a lawyer. And Don is our resident tech lawyer. He has been in Web3 and NFTs, and he's always on the cutting edge of technology. Plus, he likes to drink tea that is very fine as well. Um, Yes, as he has a tea bar in his office. And Don is here to talk about AI use policies, some of the liabilities that you might have if you're using AI internally, if you're using AI externally, and how to protect yourself um, with your policies as much as you possibly can. And Don will be here for Q&A. Please feel free to ask any questions in the chat. We'll keep an eye on it. And then also, after he talks about the policy and everything, we'll have a little open chat with Don. He stays up on what best practices are around the world, what the EU is doing, and we personally like to go with the highest standards. So while we don't have regulations in the US, we would endorse a policy that is more conservative and follows the guidelines of the EU, because those are the guidelines that are likely going to be enacted here in the US. And Don also agrees with that philosophy. And so we wanted to have him on, talk to you about why and what you need to be looking out for. So thanks, Don. Over to you.
Absolutely. Hi, everybody. So, as Nicole said, my name is Don Ho. I am a recovering attorney, recovering restaurateur. I owned a tea and coffee company. That was my EO business, which is how Nicole and I met several years ago. I sold that business uh, in 2020, and since then have been a full-time consultant in the legal tech space, first for NFTs and NFT projects, Web3 projects. I've been an investor in cryptocurrency since 2016 or so. Um, they say the way to measure it is when did you buy your first Bitcoin, and or what was the price of Bitcoin when you first bought it? And I believe I bought in at either 14 or 16,000. So I've got a good return going right now. And then kind of have been dipping my foot in the pool of all this AI, the LLM stuff. I am on the board of a couple of AI companies. Most recently, one based out of Florida, out of West Palm Beach, that's doing some really cool stuff. Yeah, and so I advise companies. So my main gig now is advising tech companies, as well as I have a beverage consulting firm, food and beverage, but mostly in the tea and coffee space. So those are kind of like my two passion projects. Now, um, as Nicole said, it's so important for companies to be aware of what their employees are doing, what their competitors are doing. There's so much potential for people to screw up, so from a legal perspective, I've seen probably close to a dozen cases now where attorneys are potentially getting disbarred. They're getting sanctioned, disciplined by their state bar associations because they're using ChatGPT to create or to handle legal research, not knowing that ChatGPT is just it guesses what the next best word should be, right? That's what an LLM actually does. And so the ChatGPT would create fake cases. The attorneys would literally just copy and paste. They wouldn't double check, and they got caught with their hand in a cookie jar. And so it's kind of like there's like a Twitter thread where it's just updating, like who got in trouble this week for not doing their job properly. There are plenty of companies that are doing that and violating copyright issues by either modifying current IP, photos, videos, etc., without permission. There's a lot of misinformation out there, so it's for us as business owners, it's really important to make sure that our employees understand the concerns and the legal ramifications, the reputational ramifications of using generative AI, right? So I want to spend the next about 30 minutes or so focusing on the intellectual property issues, data protection issues, and the ethical issues to promote sustainable and responsible business practices as it relates to like an AI use policy. um, so as AI evolves, it is becoming more adept at learning, at adapting. And while it's not perfect yet, it's getting better on as most of you can see, if you're on this call or if you're watching this video, you have some interest in the space and you can see how it can positively affect your business, as well as potentially negatively affect your business if you don't put the right parameters and guide rails in place. So let me see. So for example, that legal issue that I pointed out, a really easy way, one, to prevent that from happening is double checking cases that ChatGPT cites to. But another really easy way to do it is not using ChatGPT at all. Anytime I want to do research of any kind that I need factual data on, I use Perplexity. I feel like Perplexity gives a much more comprehensive and trustworthy source of data. They cite to everything. They give you the website or whatever that they're citing their information, their answer from, their output, versus ChatGPT, which doesn't cite at all, right? If I want to do creative writing, I'll use Claude for my creative writing projects instead of ChatGPT. So that's just part of understanding the best use case for all these different technologies out there. It's not just a one size fits all. Every ChatGPT can do everything. And that's, again, the very highest level of all of this. So let me see. So what do we expect, right? Myself and other people who are prognosticating, we see that AI is very helpful, but as it stands right now, a lot of the data that LLMs are trained on can result in biased outcomes, which can obviously negatively affect people's livelihoods, their lives, their health. So any industry, whether it's finance, investment, life insurance, actuaries, healthcare, health insurance, all of those things, if the AI is giving inaccurate data or data that is manipulated or hallucinated, those AI outputs can greatly affect people's lives, not just livelihood, not just money. It could, if it's a healthcare issue and it reads an MRI wrong, maybe it didn't diagnose a cancer, a tumor correctly or something like that. Those are all things where reliance on AI too soon will have a negative effect. And then obviously, that could lead to potential lawsuits or whatever. What I found in the businesses that I speak to, the businesses I work with, the best policy these days when a customer or a potential customer asks the business, if you're using AI, it's best to be transparent about it. It's I actually had this conversation yesterday where a woman who is a social media content manager her clients run every output she does, every potential post that she creates, they run it through Originality to see to see if it is a AI generated or not. And the problem with Originality is it's just like any other business, right? They're in the business of making money. They're not in the business of finding out the truth of whether something's AI. So we've seen we've seen examples where you run the Constitution into Originality.ai. You run Shakespeare, Shakespearean plays in Originality, and it pops up 100% AI generated. Obviously not true, but these are the potential issues that you're dealing with any of these technologies that are fairly new. Yes, I'm just seeing the notes now. Yeah, Claude 3 has better outputs than GPT-4 does, scientifically proven. So, so in addition to that, right, there are intellectual property issues. There is an active lawsuit right now, OpenAI and the New York Times. There's a lawsuit about the New York Times sued OpenAI about their use. Some of the outputs were literal verbatim copy and paste from New York Times articles. So there is a question now of, how are these models getting trained? Are they properly attributing credit to the authors of these written works or these artworks? Is there a licensing issue? Do these LLMs, or should these LLMs pay a licensing fee to all of these different models that they're building their LLMs off of? So it's essential that every business develops a comprehensive fair use policy that considers all of these legal ramifications. I want to do a really, really quick touch point on intellectual property laws, just so everyone understands the difference between a copyright, a trademark, and a patent, right? Those three. A copyright is sorry, I'm getting a call somewhere. Sorry, I gotta turn this off. Sorry about that. So copyrights are protected works of authorship, which are literary, dramatic, music, anything like that. That is stuff that's your business name, a book that you wrote, a song that you wrote, a movie, anything like that is protected by copyright. Currently, the courts in America have said that AI assisted works will never be eligible to be copyrighted because they're attributing the creative aspect of that work to AI, not to a human. And the idea is that copyrights are protecting human creations. A trademark is the protection for your brand name, your slogan, your logo, anything that's like business related to your business, your product, your service, what have you. And then patents protect the actual processes of inventions that are novel, non-obvious, and useful. So things like, well, let's do it the other way. Things that don't count as patentable would be something like computer code or a recipe for a restaurant. That's why you see a lot of restaurants or food products are very protective of their IP, of their secret recipe, right? The KFC, 11 herbs and spices. There's a reason that to this day, one company, one of their vendors supplies 6 of the herbs and spices, and the other one supplies 5. And they don't know who it is. They don't talk. And it's a closely guarded secret. Same with Coca-Cola. The recipe for Coca-Cola is a closely guarded secret where they have multiple vendors that don't know what other products are being brought in. So that's an example of that. Um, so as it stands right now, like I said, the copyright infringement lawsuits that have been filed against OpenAI and other AI companies, uh, the plaintiffs are alleging that the copyrighted materials are being used without permission to train the AI LLM systems and create new works. So it's very important to mitigate these risks if you are one of these companies, if you're working for a tech company, if you're using any of these LLMs in your creation of your product. Uh, the AI developers and companies have to implement proactive intellectual property strategies. How are you going to get around these issues so that when you create your work, um, it can be copyrightable, right? It's eligible to be copyrighted. Something along the lines of, I've seen some companies say that their creative employees will sign a statement saying that they contributed greater than 51% of the work created, and AI was only used as a fact checker or something else, that it was minimally used, so that it gets around that copyright issue. um, so yeah, it's important to document the creative process, the human involvement, to establish a clear chain of authorship that may support a claim to copyright protection. Um, all right, data privacy. As anyone here who runs any type of e-commerce or website heavy business knows, GDPR and the CCPA are vitally important to sticking with. um, Sorry, I just realized someone had a question. Uh, uh, so Jeff asks, he's curious to hear best practices and policies to govern employees' use of AI for work-related content generation. Kind of like what we're saying right now, right? Is that everybody who is touching AI in any way, that they've been trained properly for this, that they have read a internal AI internal use policy that dictates or that describes best uses, how to stay uh, in the guide rails, stay legal, quote unquote. Um, Generally, what that means is that the business owner or the C-suite needs to decide which tools are we going to use, and explain to the employees that, hey, these are the tools you're allowed to use. You can use Jasper, you can use Perplexity, but you can't use OpenAI or GPT-4 for research, right? You can use Claude for creative writing. But I mean, I get 4 newsletters a day that talk about all the new tools that come out. And some of them are really, really cool and very helpful, like Claude and the other LLMs. And some are cheap knockoffs made by some Eastern European company that's not registered in the United States, and they're asking you for $50 a month. And there's barely an MVP product or service, So you want to stay away from those companies. So as the business owner, you have to take the time to do that research and figure out, okay, what are the best tools, what are the best software websites that make sense for us to implement into our business, and then make it a policy that, hey, these are the only websites you can use to help with content generation or bookkeeping or whatever it is. There's a company for everything these days. And that's something where maybe you do hire a consultant like Nicole's firm, to help, because they've done all of that research. I still, to this day, if I find something I haven't heard about, I'll text Nicole and ask her, hey, what's the deal with this? So Andrea, you have a question?
Yeah, I did. And I wanted to add on to what you were saying too, because Jeff, that's a good question. Because that's something we've been doing, is that internal and external policies and being transparent about the use of. But not only deciding what tools, but like Don was saying, the cases for the use of each item, right? Because like accounting, you definitely want to be clear about what they can and can't use, and customer service will be another thing. And then maybe your, of course, social media people, they probably have a lot more tools than some of the other departments, but just being clear about which ones are approved for use and which ones aren't, and use for what. So it's those two things. I did have a question about the copyright thing because I found that was really interesting, that you're not going to be able to copyright things that you generated with AI.
AI generated works.
But then I heard you say something about percentages. So that made me think that there are some things there of like, if you've done 80% of the work and AI has helped you with this, like, are there parameters, and like, what are those?
There's nothing official, like official law that's passed. What this all is, we're in the Wild West right now, right? I was telling a story. I was on a panel last week at a conference. I was telling a story about how um, in college, I put myself through college. I was working in a call center selling women's clothing. It paid well. Okay, don't judge. But
No judgment.
this is in 1998, and I was one of like 3 people out of 100 in the call center that understood what the internet was and had an email address. So they put me in charge of creating. Keep in mind, I'm 19 years old. And they put me in charge of creating the customer service e-commerce department for this $100 million company. And so I did it, but it's the Wild West. Like the very first version of that website was they had a shopping cart, but because back then people didn't want to put their credit card number on the website, they'd place an order, we'd get it, we'd call the customer and take their credit card number over the phone.
And that seems safer.
That seems safer to have some random stranger call you
right?
and say, "Hey, give me your credit card number," than giving your credit card number
Right.
over the internet. So that's the thing, right? We're still so new in all of this. A big part of what I do in the NFT space is this NFT a security or not, right? That sort of thing. Does it pass the Howey test? So same issue here. Just like you're saying. Is there a certain percentage that will make it, not AI generated? We don't know the answer to that yet. The only thing that we know for sure is the USPTO, Patent Trademark Office, has said AI generated works will not be copyrightable. That's all we know for sure. So when I say that the workaround that people are finding, it's trial and error. It's still a gray area, so people are just throwing stuff against the wall and seeing what sticks. What works with the government, so there's a lot of stuff. If you're into government contracting, you can't be a vendor for the US government, federal government, unless your company is doing more than 51% of the business, of the service or the product. So that's where people are kind of taking it from that industry and applying it to AI, saying, okay, well, if I'm writing 51% of this work and I'm just having AI, help kind of clean it up, edit it, stuff like that.
It's like, how would that ever be measured? Like that's
exactly right.
Yeah.
Right. So it's one of those things that's, that's the argument that people are making. We'll see if it holds water. We'll learn through litigation and through legislation over the next, 3 to 5 years or so, whether or not that's actually going to hold water.
Yeah.
Fair enough.
I have a question as well. I'm going to post an
Katie.
image in the chat. And so my one of my good friends is an artist, and she's involved in the lawsuits with Stable Diffusion, Midjourney, and a few other generative AI tools. And this image here in the chat is her image that she painted, hand painted on the right. The image on the left is generated by AI, and
Wow.
it's like almost an exact copy. And her whole stance, AI is theft because it is clearly affecting her career. We teach, when we're working with these generators, we absolutely teach never to use living artist names and prompts specifically because of this. But it made me think, like, when we're creating our own works, our own copywriting, our own products and services, like, how do we prevent AI tools from like doing something like this and copying our own works?
So keeping in mind everything I just said 5 minutes ago about written works, artworks are even further behind that. There is no standard at all. I'm looking at this photo. That's a pretty blatant ripoff, right?
Yeah.
That's, you know, she doesn't have the tree growing out of her hair, and she doesn't, you know, in the AI version, and she doesn't have, like, I guess, is that roots around her shoulders, the shoulder blades. But besides that, it looks almost identical. So yeah, that's crazy. Look, here's what I'll say. You know, and this is a conversation I have with my wife as it relates to our children. We've got 3 young kids, 11, 6, and 4. And I have been saying this for a decade plus. We don't know what the world's going to look like in 15 years, in 10 years, in 5 years. You know, growing up, just kind of looking at the audience right now, it looks like everyone is kind of in that, you know, millennial age, maybe Gen X age. But, you know, the point being that there was no such thing as a social media influencer, right? Mr. Beast did not exist, and that whole industry didn't exist until approximately 10, 15 years ago. When automation happened in the industrial, you know, industrial revolution, you know, miners and farmers got, you know, they had to be reskilled, you know, learn new skills. It's anticipated now that software developers and white collar jobs are going to get eliminated. I've been saying for years, since probably 2010, that transactional attorneys are going to go the way of the dodo bird, you know, before the end of our lifetimes. AI can review a contract. If they have a good model to work off of, it can do a contract review 10 times faster than me and more accurately than me, as long as the model is accurate, right? And that goes back to prompts, right? So from a consumer point of view, when you use ChatGPT and Claude and whatnot, your outputs are going to largely be affected by the prompt that you use. So just like anything else, like I said, as it relates to contracts, if you give an AI enough good contracts to review, and then you give it something to review, it's going to do it way better, way faster than any attorney is going to do it. Are we there yet? Not yet, but will we be there in the next year or two? I think so. You know, just based on what I see with talking to my attorney friends and stuff, it's kind of crazy how quickly the paradigm, how quickly the paradigm has shifted, at least in terms of transactional work, estate planning attorneys, contract attorneys, stuff like that. AI is gonna revolutionize that. Bookkeeping services, same thing. The other side of the coin is litigation attorneys, trial lawyers. Those people, you know, they'll never let an AI handle a case, handle a trial, right? So trial attorneys are safe. They're not going anywhere because that's performance, that's acting. So that's an industry, that's a segment of the legal industry that's not going anywhere. So I guess my point is, you have to adapt, right? COVID was the start of this, right? Is every business person, word of the year was pivot, right? My wife shudders every time she hears the word pivot, still to this day. But that's the truth, right? With AI, we have to learn to pivot, and we just got to make sure that as you're pivoting, you're not doing anything that could potentially lead to legal ramifications that could hurt your company or take it down. That's really what my concern is, and me wanting to educate people is all about. Was there another question? Change is certain. Yes, it is. Any questions from the audience? Anyone else before I get into the next thing? No?
Looks like Dan has one. He's got his hand raised.
Oh, sorry about that. Sorry, Dan.
Hey, no worries. Hey, so it's interesting. I've been a lawyer for 3 decades myself, and I'm in recovery too. You use that phrase because I tell people all the time, you get the joke better than anybody. So I posted an image in the chat, kind of to make a point. I mean, that's one of the most recognizable, valuable pieces of pop art in American culture. That's Andy Warhol. And
I don't see anything.
Oh, I put the Campbell soup can.
Oh, okay.
Maybe you can't see it, but
yeah.
The law has a way of figuring these things out. But to your point that it's the wild, wild west at first, I've already seen as kind of a change agent in the law directly that the first people that charge the hill tend to get very, very bloody, and then you look back a year, 5 years, 10 years, and the things that people were getting punished for and sanctioned for and losing judgments around become very de rigueur. Like that's just the way things are done, and everybody accepts it. And there have been phase changes before. I mean, I think in terms of art, for instance, there was a lot of discussion no more than 20 years ago around artists who were using electronic tools to create works of art, and whether that met the standard of intellectual property such that it could be protected by trademark or protected by copyright, depending on the nature of the piece that was being created, but copyright in particular. And it will catch up. The thing that the law struggles with is change happening as rapidly as it does, because the law is very stodgy, and it typically requires legislative cycles, or it requires litigation to run its course, and not just at the trial level, but it requires it to go up sometimes a couple levels of appellate courts before you start establishing a standard that then starts to permeate other jurisdictions and things like that. One of the good pieces of news, I suppose, about this, though, is that the federal IP system is federal. So copyright, trademark, and patent are all federal systems, and there are state law analogs for them that might be more of a hodgepodge. But at least if the PTO starts developing some guidelines around this, it's going to start to standardize things, relatively quickly. But I think the key to a lot of this, and I'd be curious about your reaction, Don, is this idea that what's being protected is intellectual property. And so this idea of saying I created at least 51% of this work is really a surrogate for the idea that this is a product of my intellect, because that's what we're trying to protect, is people's idea making, so that they can potentially monetize those things and protect those things with a measure of security and predictability. So, while that image that you put up is a blatant ripoff, and it's a product of the fact that somebody said, create the following kind of image in the style of this particular artist. And so the LLM went out and found an image from that artist that looks very similar and made minor changes. That's literally what happened, right? It strikes me that this is also a matter of how you prompt engineer, right? You've got to ask the right questions to get protectable answers. And then if you do, I think even in the fiction space, you probably could use AI to assist in the process. In the nonfiction space, I think you clearly can, as long as you're attributing sources. And that seems to me to be less of a lift. So anyway, just curious what your reaction to any or all of that was.
It sounds like this should be a panel discussion with you and me, Dan. that was very eloquently put. Yeah, as it relates to IP and, how do you document, right? That was Andrew's question. How do you document something that's 51% or 70%? Are you using AI for idea generation, or are you using it to clean up and edit? Those are all questions that like you said, will be figured out in the courts or through legislation. What we can say for now is ways that you can kind of protect and show the attribution, the percentage attribution. Like I said, some of these companies that I'm talking to, they're requiring their employees to keep track of all of the searches, all of the prompts that they're using. So, I think actually most of the LLMs do a good job of that, right? That they'll actually save the prompt that you use. So I'm not sure how long they'll save them, but maybe you make it part of the policy that everyone starts off in Google Docs, and if you're going to use AI, you have to copy and paste the prompt that you use to get that, so that if anything happens, right, it's just like any type of litigation, you have that documentation to show this is what I asked the LLM to do, this is the result it gave me, and then from there, this is my end result IP work that I created. Yeah, that's another tool or policy that you could put into place, maintaining use records, maintaining prompt records of the AI tools that you're using.
Yeah, that'll be an interesting thing, and probably the power of written processes is really going to be where it's at. Making sure that people do prompt it a certain way, because yeah, I'm not sure how feasible it would be to keep all your prompts, because it's usually not one prompt and you're done, depending, and that's depending on if you're doing an image or writing or whatever it is, like there's multiple steps, and like to keep everyone, like I don't really think that's something you would or even could do. But yeah, I mean, I get what you're saying. It just seems like this is where SOPs are going to become like really important.
Right.
Yeah.
Exactly. And that's part of it, right? Creating those SOPs to show, hey, these are the steps we always do. Dan, I'm sure you can back me up here. When you were lawyering, we had SOPs for everything. So that, I started out as an estate planning attorney, and I got taught by my mentor, we do everything the same way. Every time we do a signing, right, a trust and will signing, we did it the same way every single time. So if we ever got called in on a probate matter, we can say, well, I don't remember this specific client, but I can tell you that I've been doing this exact process for the past 20 years, and we do it this exact way every single time. And that will fly in court,
Yeah, it's a standard of care proof, so that you don't get hit with a malpractice claim. It works in practice areas that tend to have process-based services. I was a corporate restructuring guy and spent a lot of time in a bankruptcy courtroom, and there the patterns are less clear and less constant. But yeah, I've seen standard of care proffers before on that kind of thing.
Yeah. And at least on the local probate level, they almost always that argument works. Jeff had a question in here somewhere, or a statement. I heard a conversation today about not using our actual company name so as to protect some level of privacy. Yeah. I mean, the issue is if you get sued somehow, there's still going to be some type of you're going to have to produce something, right? Like I mentioned, the attorneys, they're literally dragged into the state bar tribunal and basically forced to answer. How did you find these? What did you do? What were the prompts that you used? And they had to, like, it's like Scarlet Letter. I used Chat GPT.
Yeah, and to be honest
Don is
with
a
you,
litigator. I could add something about preservation of digital records. I mean, if you're anticipating litigation, there is actually a very well-established standard that you have to put a litigation hold on all forms of digital records and digital communications. And I think there is really an interesting question around whether that would include your interactions with, LLMs and that sort of thing. So regardless of whether you're using the company name, I think that has to do with whether or not somebody could in the public space find out things about you that you don't intend to make public. But in terms of the use of it, if you got into a lawsuit with somebody about whether you did or didn't do something properly, or whether you protected their confidences, or whatever the case may be, I think as soon as you're aware that there's the potential for litigation, you've got a duty to preserve the record of your electronic interactions with those systems.
Dan, were you going to say something? Or Jeff, I mean, sorry.
no, I didn't have much to add. As a matter of fact, he hit on the point that I was actually trying to make, which is making accessible information that we would typically have behind our chest open to the public. That was the conversation today, which was what kind of policies are we going to put in place around allowing our employees to use any form of AI. And the concept or the comment was made around not using our name specifically as we're generating any prompt, so as to not allow non-public information potentially to leak out into the public world. The organization I was with today is, I mean, they've got some 15,000 employees, which is where the conversation was going.
Well, in those
Yeah.
cases, you would probably just want to use systems that are closed instead of systems that would put your information out into the world. And that would stop that risk of that ever being a thing. And that wouldn't be ChatGPT. That would be a place where you had some control, because if you are worried about that sort of thing, that's why what you pick as far as tools is so important. It's like putting yourself out on the internet. Like once you put your stuff on social media or the internet, like anybody can find it forever, right? That's kind of what you're doing on ChatGPT. I mean, there are parameters you can set, but I don't know. Does anybody really know if those settings are working or where that stuff is going? I don't really know, but I do know that there are closed systems, and that's what you really need. If you're really worried about protecting that kind of information and not putting it out there, that's what you need to be using, is a closed system.
Yeah, I definitely use ChatGPT. Like it has the same type of like publishing as Facebook going public, or any social media, MySpace even. Like it's out there and it's on the net as soon as you put it there. I assume anything I put in ChatGPT might later be on the internet somewhere. But if I do want to work on something that I don't want the world to see, I might use something like Jasper or something different where it is closed. And there are companies that have custom AI solutions built for them that are hosted on their own servers. So they don't even have to, use any of these other like ready-made solutions. They use something that's custom built for them.
So
Yeah.
there's
Law
actually a
firms.
nuance that, since we're talking legal stuff, probably makes sense to bring up, and it has to do with this disclosure of what could be proprietary or confidential information. There's two levels of concern around this. One is not letting something out because you just don't want anybody to know about it, right? Whether it's protectable or proprietary or not, right? You just don't want it out there. And so there, obviously, the practical solution is to try and make sure that you're interacting with the system in a way that protects it. The second piece of it, though, has to do with protecting the proprietary or protectable nature of things. And there, as long as you're taking reasonable precautions, let's just say you were interacting with an LLM that you thought was secure, or a system that you thought was closed, and it turns out behind the scenes it wasn't as closed as you thought it was. The law generally requires you to protect the proprietary nature of your information unless it's got an independent kind of trademark or copyright or patent on it, right? So if you want to say it's proprietary business secret, you've got to take reasonable precautions around it. An inadvertent disclosure of it might not destroy the protectable nature of it legally, but it still gets it out there. Everybody knows it once it's
over, once it's out there. Yeah.
But I think that's an important distinction because they both militate in favor of trying to figure out how to protect things, as thoroughly as you can. But you might not, if you had let's just say the recipe to Coca-Cola. And Don, I don't know if that's a patented, recipe or if that's just a trade secret. I think it's a trade secret.
It's a trade secret.
Yeah. I mean, you could still protect it as a trade secret if, despite your best precautions, it leaked out somewhere. You could go get an injunction to stop somebody from spreading it or something like that. But once it's known by somebody, it's known by them. You can't get it out of their head.
Yeah.
Exactly. Yep.
Yeah, it's an interesting area, isn't it? So I guess it's like take any steps we can now to protect our information, regardless if it's going to be copyright or not copyright. If we can be on our own closed systems, that's going to help keep that security a little bit, and then covering ourselves with these internal and external policies and being transparent about the use. Because don't you think that also protects you in letting people know that you're using AI and that there could be kinks or, things that happen with it, but being like forthcoming with that information?
I've got a client who is a technology consultant to Fortune 1000 companies, and his policy that he wrote says that very thing. We are very transparent. We're going to use AI tools to help improve your company and our advice and counsel to your company, but understand that everything I use, I have double checked the outputs, and I stand by everything I say, just as I did before I used an AI tool. So he makes that part of the retainer. So because he is in technology, I think he even put it on his website. But it's that transparent that, hey, these are all tools, just like any other type of tool. It can be used for good or it can be used for evil. And I'm putting my name behind it and my reputation behind it. I mean, that to me is the best policy, right? Honesty is the best policy. Just be truthful about it. Explain how it helps and benefits the client for you to use it, whether that's a time savings or cost savings or whatever. And just stick with it. And I think that's the last thing I would want to say is, a use policy, internal or external, is not a single document that is written and then signed and just thrown into an HR folder. It needs to be a living document. It needs to be visited every 3 to 6 months, for the foreseeable future, because, like I said, things are changing on a daily, weekly, if not daily basis right now. So, the world's changing, and you're either going to change with it or your company's going to get left behind.
Agreed. Thank you for that.
Absolutely.
And something else on the privacy policies and kind of what Jeff was saying, it's important to know with the tools that you use what their privacy policies are, because like ChatGPT, Sam Altman says, we don't use your information for training. It's protected. But if you have a business account, you get your own sandbox. So it's a bit more protected. And if you're using the API, it's even a little bit more protected. And if you're using Jasper, you're in your own environment and you get to use 12 different LLMs to generate content, but all your content is kept in a space. And you have a complete history and record of everything you've ever done. And same with the business accounts too, unless you actively delete it, but you would have that evidence should you need it. When you have those business accounts and they're contained in your own, they call them sandboxes or your own environment. That has, I don't know if it's a sandbox size wall around it or how big the wall is. It depends on how custom. But then there are some of the visual platforms, like Adobe's Firefly, they have a watermark that says this was an AI generated image. So anywhere you use it, you have that watermark on it. But then there are some others like Ideogram, and they say whatever you create on our site, we're not responsible for the use of it after it leaves our site. And so they just like wash their hands. I'm done with it. And, don't take any responsibility. And Sam Altman has said that he will back his users up in, with legal support because they want to, they want to build that trust and say that what they're providing is, and Andrea, how does Jasper put it? It's, plagiarism free.
Oh, yeah.
Plagiarism free.
99.99, I don't remember the exact number, but it's something crazy. And they also have a plagiarism checker as well, but they have never had a case of any sort of plagiarism issue in Jasper.
You know what I'll say about that, Nicole, is that example you gave, not Adobe, but the company you mentioned after that says we're not responsible. Yeah, that's akin to when you valet your car and the valet, has the disclaimer, says we're not responsible for any damage.
Yeah.
Well, if your valet goes and crashes the car as he's parking it, they're going to be responsible. Just because you say, I'm not responsible doesn't mean that you are off scot-free of any legal liability, just because you say that. So we'll see what happens. I'm not saying that it's definitely going to be bad for them, but it's too early to tell. So,
hey, Don, would you agree that same line of thinking, like if you had a clause in your contract that says, hey, customer, we use AI and we take, reasonable precautions, but when you hire us,
but
you're exposing yourself to this. I mean, my guess is that probably saves you from liability as long as you act in a commercially reasonable way. But if you don't, then I think you're probably still exposed, aren't you?
Potentially. Oh yeah, absolutely. So to me, all of those types of things, the valet example I gave, NDAs too. I'm a huge believer in an NDA isn't going to stop anybody except the lowest of the low people who don't understand. Well, we can't sue the valet because the receipt said they're not liable. You tell one person a business idea that you put a NDA on. Well, we can't sue them because they said it was an NDA. Same idea, right? It's going to stop some people because, well, that's what I signed, so I guess I can't do it. But anybody who goes and talks to an attorney or an expert, there's going to be gray areas. There's going to be this is all going to work itself out over the next whatever decade plus. So yes, I do agree with you. It will affect some, but not everybody. Thank you, Dan. Appreciate it.
Yeah, I think this means you're going to get really busy before you're not needed anymore, huh?
One of these days I'll
go
get
out
8
with a
hours
bang,
of sleep.
right?
Yeah.
My wife sent me a meme last night saying it's like, hey, I got 8 hours of sleep. Finally. It took 3 days, but I got 8 hours of sleep.
Right? I know. Well,
yeah.
I mean, because we're all in this same world, we're just in different areas of it. It's just all the time these new developments and which is exciting and energizes you enough to keep going, right? and it's fun, and it's you get to learn,
it's just
and
the stuff. Yeah, the stuff that is so easy to find now You know, I was on a call with one of my mentors this morning, and we're pitching a company tomorrow morning, so we're doing a prep call, and he goes, "I wonder how much they do in business, on an annual basis." And as he's talking, I'm like, "Doot, doot," and I found it. I have an AI tool that scrapes their website and can find out. It didn't find out the revenues, but it found out sales volumes. You know,
Mhm.
and I found it in 5 minutes, not even 5 minutes.
Yeah.
And he's older. He's early 70s. So he's like, "How'd you do that?" I'm like,
Mhm.
I got my tricks.
And I think
Uh,
that is the best part. And that is like perfect illustration of to upskill your workers. Like you're upskilled, you occur as more valuable because you can do these magical things. And that's what we keep emphasizing too, is upskilling workers, because the service that you could provide in that, the super quick turnaround and that information, you look smarter. And it's the people who have the wherewithal to be able to use these tools that are really going to accelerate. And the people who don't have as much world experience are going to really need to learn these tools to even have a chance of keeping up.
yep. Yeah. No arguments for me.
Mhm.
Yeah, you look like a magician.
Yeah.
You guys look like magicians too. Uh,
Well, thank you so much for this. I'm going to turn off recording and then we can wrap up because I want to hear what tool you're using. Thank you for being here, and as always. And I know we're going to bring Dawn back for a workshop very soon. So thank you.
absolutely.